There's a knock at your door. You look through the peephole. Men in vests, badges. One of them holds up a piece of paper and says, "We have a warrant. Open up." Your heart stops. You think they have a warrant. I have to let them in. So you open the door, and in that single moment, you handed over your home, your rights, and possibly your future. Not because the law required it, because you didn't know that what they were holding wasn't a real warrant at all. Every day across America, people open their doors, hand over documents, and answer questions during ICE encounters because they believe they're legally required to. They're not. There is one specific document ICE will show you and call a warrant that carries no legal authority to force entry into your home. There are questions ICE will ask that you have a constitutional right to refuse to answer. And there are things people sign during these encounters that permanently eliminate their right to a hearing before an immigration judge. I've reviewed hundreds, and if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Of immigration enforcement cases, studied federal court decisions going back decades, and analyzed the exact documents ICE uses in the field. I've identified 4 critical mistakes people make during ICE encounters. Each one hands officers legal ammunition they didn't earn. Each one can be avoided. Here are the 4 mistakes and the exact phrases that protect you. This is educational content only, not legal advice. For guidance on your specific situation, consult a qualified immigration attorney. Mistake 1. Opening your door because ICE showed you a form I-200 or I-205. The mistake. ICE agents knock. One holds a document up to your door or against the window. It has official government letterhead. It uses the word warrant. You think, they have a warrant? I have to open up. So you do. You just gave them something no court gave them permission to take. You're home. The scenario, it's early morning. You hear a knock. Through the window, you see several officers in tactical vests. One holds up a document and says clearly, "We have a warrant for this address." The word warrant alone triggers everything you've been told your whole life. You open the door. Officers enter immediately. The encounter that follows happens inside your home, on their terms. But here's what that document actually was. Why people do it. The word warrant carries enormous psychological authority. People associate it with court orders, judges, legal compulsion. Officers know this. They're trained to present these documents confidently and decisively. Most people never stop to ask what kind of warrant it is. Legal reality? There are 2 fundamentally different types of warrants. A judicial warrant is signed by a federal magistrate judge or district court judge. It is issued under the 4th Amendment and authorizes entry into a private home. The other type is an administrative warrant, specifically ICE forms I-200 and I-205. These are issued by ICE officers themselves, not by any judge. The Form I-200 is a warrant for the arrest of a non-citizen believed to be in violation of immigration law. The Form I-205 is a warrant of removal for someone with a final deportation order. Federal courts have repeatedly held that administrative warrants do not carry the same 4th Amendment authority as judicial warrants. As recently as January 2026, a U.S. district judge ruled that forcible entry into a home using only a Form Y-205 violated 4th Amendment rights. The legal status of these warrants in the home context is actively being litigated right now. What is settled is this. You can check evidence problem. If you open the door, courts will treat that as consent. Officers will testify and body cameras will show that the door was opened voluntarily. Any evidence gathered inside, any statements made inside, will be argued as the product of a consensual encounter. Your attorney's ability to challenge what happened is severely weakened the moment that door opens. How to identify the difference? A judicial warrant will display the name of a federal court at the top, such as United States District Court. It will be signed by a judge or magistrate, not an immigration officer. An administrative ICE warrant will display Department of Homeland Security at the top. The signature will be from an authorized immigration officer, not a judge. The correct move. Do not open the door, speak through it or through a window. Here is line 1. Slip the warrant under the door. Say it calmly. Say it clearly. If it is a true judicial warrant, you will see a court name and a judge's signature. If it is an ICE administrative form, and if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. You will see Department of Homeland Security at the top and an officer's signature. At that point, you can say, "That is not a judicial warrant. I do not consent to entry." You are not being obstructive. You are exercising a Fourth Amendment right that federal courts have repeatedly upheld. The body camera outside your daughter will show you acting calmly and lawfully. That record protects you. Bottom line, never open your door based solely on the word warrant. Ask them to slide it under the door. Check for a court name and a judge's signature. If it lacks either, you are not legally required to open that door. Mistake 2. Answering questions about where you were born or how you entered the country. The mistake. ICE agents approach you in public, at work, or after gaining entry. They ask, "Where were you born? When did you come here? Do you have papers?" Most people answer because they think silence looks guilty or because they believe they must answer government officials. Every answer you give becomes evidence that can be used against you in immigration court. The scenario. Officers approach you outside your workplace. One asks, "Sir, where were you born?" You say the name of a country. He writes it down. "And when did you come to the United States?" You give a year. "How did you enter?" You explain. You've just handed them the 3 pieces of information most needed to begin removal proceedings: your foreign birth, your entry date, and your method of entry. None of that was required. Why people do it? People believe that cooperation signals innocence. They believe that if they have nothing to hide, silence seems suspicious. Officers reinforce this. They speak conversationally. They act like the questions are routine. Sometimes they suggest that answering now will make everything go faster. Legal reality. The Fifth Amendment to the United States Constitution protects every person on U.S. soil, regardless of immigration status, from being compelled to be a witness against themselves. The Supreme Court held in Miranda v. Arizona in 1966 that the right against self-incrimination applies to all individuals, not only citizens. This means you cannot be legally compelled to answer questions about your birthplace, the date you entered the country, or how you entered. Your immigration status, your country of origin, and your manner of entry are all information that can be used directly against you in immigration proceedings. You are not required to provide any of it. Evidence problem. Unlike in criminal court, the exclusionary rule generally does not apply in immigration court. This means that even if information is gathered in a legally questionable way, it can often still be used against you in removal proceedings. Every statement you make voluntarily becomes part of the record. There is no taking it back. Officer psychology. ICE agents are trained to establish rapport before asking substantive questions. They may ask your name, comment on the weather, then slide into questions about your background. The transition is designed to feel continuous and casual. By the time the question about your birthplace arrives, you're already in a conversational rhythm. Breaking that rhythm feels unnatural. Officers count on that discomfort. The correct move. Here is line 2. I am exercising my Fifth Amendment right to remain silent. Say it clearly. Say it once. Then stop talking. If they continue asking questions, repeat it. Do not explain why you are remaining silent. Do not apologize. Do not add anything. The invocation is the protection. This matters because of Salinas versus Texas, decided by the Supreme Court in 2013. The court held that simply staying silent is not enough to invoke Fifth Amendment protection. You have to say it out loud. Silence alone without explicit invocation can be commented on as evidence of guilt. The words are the shield. Bottom line, never answer questions about your birthplace, your entry date, or your immigration status. The moment you are questioned by ICE, say the words, I am exercising my Fifth Amendment right to remain silent, and then exercise it. Mistake 3. Signing a document ICE presents during or after detention. The mistake. ICE places a form in front of you. An officer explains it quickly or not at all. You feel pressure. You want to cooperate. You want the encounter to end. You sign. You may have just signed away your right to see an immigration judge entirely. The scenario, you've been detained. An officer hands you a document and gestures toward the signature line. He may say it's routine. He may say it will speed things up. He may not explain what it is at all. You sign. Days later, you learn that the document was a voluntary departure agreement or a stipulated removal order. You have waived your right to a hearing before an immigration judge. The process that could have taken months or years has been compressed into a signature. Why people do it? Detention is disorienting. People are scared, tired, separated from family, and often do not speak English as a first language. The instinct is to comply, to be cooperative, to do what it takes to get out or to avoid making things worse. Officers presenting documents in that environment carry enormous authority. Refusing to sign feels dangerous. Legal reality. Under U.S. immigration law, non-citizens generally have the right to a hearing before an immigration judge before being removed from the country. Signing a voluntary departure form or a stipulated removal order can waive that right. These are not administrative formalities. They are legally binding documents with permanent consequences. You cannot be forced to sign them. No legal obligation requires your signature on any ICE presented document without first consulting an attorney. Evidence problem. Once signed, these documents are extraordinarily difficult to challenge. Courts have consistently upheld signed voluntary departure agreements and stipulated removals even when signatories later claimed they did not understand what they were signing. The signature is the record. The burden falls entirely on you to prove it was not knowing and voluntary. Officer psychology. Officers may present signing as the easier, faster, or more cooperative path. They may describe the document in vague terms. They are not required to explain the full legal consequences of what you are signing. The pressure of the detention environment, combined with the authority of the officer, makes resistance feel impossible. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. It is not the correct move. Here is line 3. I do not want to sign anything until I have spoken to an attorney. Say it calmly. Repeat it if pressed. You do not need to explain further. You do not need to argue about what the document says. The refusal to sign without counsel is a right, and exercising it cannot be used as grounds for additional punishment. Bottom line, never sign any document presented by ICE without first consulting an immigration attorney. The phrase is simple. I do not want to sign anything until I have spoken to an attorney. Those words can preserve your right to a hearing that could change the outcome of your case entirely. Mistake 4. Not asking, am I free to go? The mistake. ICE stops you on the street. E stops. Outside your home or at a work site. They ask questions. You answer some, refuse others. Then the interaction seems to trail off. Officers don't leave. They don't formally detain you either. You're not sure what you are, so you just stay there, waiting. Every second you wait without asking that question, you are voluntarily extending the encounter. The scenario. An officer approached you outside a convenience store. You invoked your right to remain silent. He hasn't arrested you. He isn't walking away either. He's standing near you, occasionally asking questions you aren't answering. 5 minutes pass. 10, a second officer arrives. You're not in handcuffs, but you're not leaving either. Without asking the critical question, you have no legal clarity on what this encounter actually is. Why people do it? People assume that an ICE encounter continues until the officer says it's over. They're afraid that trying to leave will look like guilt or will trigger an arrest. They don't know that there are legally distinct categories of encounter and that in some of them, they are free to walk away. Legal reality. Terry v. Ohio, decided by the Supreme Court in 1968, established 3 types of police encounters. A voluntary encounter in which you are free to leave at any time. A Terry stop, in which an officer briefly detains you based on specific, articulable facts suggesting criminal activity. And a formal arrest. In a voluntary encounter, you can simply walk away. The officer cannot legally stop you, but you have to know which one you're in, and the only way to find out is to ask. Evidence problem. If you remain in an encounter voluntarily without asking whether you're free to leave, courts will treat the entire interaction as consensual. Any statements you make will be characterized as voluntary. Any cooperation you show will be documented. The body camera doesn't know you felt you had no choice. It only records what happened. Officer psychology. Officers have no obligation to tell you that you're free to leave. They are not required to end voluntary encounters. Extended voluntary encounters give them more time, more opportunity to observe, more chances for something to develop into probable cause. Staying silent about your right to leave is entirely in the officer's interest. The correct move. Here is line 4. Am I free to go? Ask it clearly and calmly. If the answer is yes, say thank you, turn around, and walk away. Do not run. Do not explain where you're going. Just leave. If the answer is no, you now know you are being detained. At that point, immediately invoke line 2. I am exercising my Fifth Amendment right to remain silent. And line 3 if they produce documents. I do not want to sign anything until I have spoken to an attorney. Why it works. This question forces legal clarity. If the officer says yes, the encounter is over. If he says no without articulating legal grounds for detention, your attorney now has a documented basis to challenge the legality of what follows. Bottom line, never assume an ICE encounter is still required just because an officer hasn't walked away. Ask directly, am I free to go? If yes, leave immediately. If no, stay silent and request an attorney. Here are the 4 lines one more time. Write these down. Put them somewhere accessible. Practice them until they come automatically, because when your heart is racing and an officer is in front of you, you will not have time to think. Line 1. Slip the warrant under the door. Then check for a court name and a judge's signature. Line 2. I am exercising my Fifth Amendment right to remain silent. Line 3. I do not want to sign anything until I have spoken to an attorney. Line 4. Am I free to go? 4 lines. That is your legal framework for every ICE encounter. Stay calm, stay polite. Do not run, do not lie. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Do not hand over what the law does not require you to give. This is educational content only and not legal advice. Immigration law is complex and every situation is different. Before any encounter, consult a qualified immigration attorney who can advise you based on your specific circumstances. Many provide free consultations. If this video helped you understand your rights, hit that like button. Subscribe for more breakdowns of laws that directly affect your life. Share this with everyone you know, because this information is most useful before an encounter, not during one. The most prepared person in that encounter isn't the one who talks the most. It's the one who knows exactly which words to say and exactly which document to never open the door for. Stay calm, stay informed, know your rights.